Does estate planning always include a trust? The short answer, no. Let's explain a little bit more in detail. A good estate plan is unique for each person. Some people have no need for a trust, while others may benefit greatly from having one. To determine if a trust is right for you, a Dummett Fraden estate planning attorney needs to fully understand the bigger picture of your assets and property and how you want those distributed upon your death. There are several reasons for trusts. Here are some of the most commonly encountered reasons why you may want one. Young kids. If you want to provide for young children who are not ready to manage money for themselves, you could consider a testamentary trust, which is a trust set up by the terms inside of a will that never happens until your death. Then, your named trustee, who you would choose, will look after your kids' money and property until they grow up and are able to do so for themselves. Another reason is pets. Similar trust provisions can be made to provide for pets to the ones that are used for young children. Persons with special needs is another example. A special needs trust can be implemented to provide property to care for a child or beneficiary with special needs who may never attain the ability to manage his or her own property. Another reason is avoiding probate. Probate is the process whereby the courts manage a deceased person's estate after that person has died. In some cases, it can be a straightforward process, but for many people, it can be stressful, expensive, and lengthy. A living trust can be used to help avoid a lot of the hassles involved in the probate process because it allows the trustee to deliver your property to beneficiaries without needing to go through a probate court at all. For this reason, some people refer to living trusts as will supplements. You still need a will, but it can be very simple and private if you have most of your property already in the trust. A final reason is privacy. You may want a trust simply for the additional privacy that it provides. For example, if you only have a will when you die, that will gets submitted to the probate court, and the will itself becomes a matter of public record. In other words, any person who really wants to see what's in the will can do so, which can make for some interesting conversations among family who may not have been included. But also, it just exposes your private property and affairs to public review.